One thing comes to my mind with wills is validity, a will being valid. Can you go through quite quickly, what are those elements that make a will valid?
All right. By now, it should be known to our listeners, and there are let's say 3 to 4 very important things. Most importantly, the person making the will must be over 18,
Right.
generally. So that is
Mm-hmm.
fairly easy. And next
Mm-hmm.
very important fact is that it must be dated.
Right.
18th of February 2025, 2021. Third point, you must have 2 witnesses,
Right.
and you must sign at the end of your will, and
Mm-hmm.
then the witness's signature come right after yours, and it must happen at the same time. And then, of
Right.
course, a very important point, if I could add number 5, is that there must be evidence that you were in your right frame of mind when you made your will.
Right. And of course, it goes without saying that
Essentially.
it must be written, right? So we have a written document that have these essentially 5, features to confirm its validity. Must be written, have your witnesses, person of valid age to write the will, and must be dated and executed or signed, right? Now, if you die without doing same, and you're left with the situation of intestacy, what are the consequences of this?
Right. Intestacy, as we are saying, without a will, has very, very serious consequences. We could run them through very quickly. To me, one of the most important things is that you have not been able to give your final wishes.
Right.
And as such, persons who you may not want to benefit from your property are the ones who will benefit, right? So, and then some people are very concerned about the disposition of their body after. You have not been able to say Catholic rites, no rites, burial, cremation at sea, nothing like that. So you leave your family members in a quandary as to how to dispose of your body,
Right.
right? You also have to my mind, one of the very important issues that you may be estranged from a family member.
Right.
And that is the very person who is now benefiting from what you have left. Because once you have not said jewelry to go to Jane, car to go to Harry, we have to follow the law of succession and give your property to your next of kin.
Right.
When you make a will, you determine who gets what you have left. You
Right.
leave no will. An estranged husband comes in, an estranged wife comes in, and you cannot do anything about that because your final document was not available to anyone because you did not do anything. And then sometimes it costs a whole lot more in terms of headache to family members and undue estrangement and uncertainty. And family members at that point in time, there's some kind of consolation in knowing that I have done what Mary wanted
Right.
as final rights, as opposed to
Yes, sir.
somebody who, just stepping in and,
Yes.
doing whatever they want,
Right. So
right?
would it be correct to say or accurate to equate, right, if you die without a will, you are essentially permitting the courts or the law of the land to dictate what your final rights are?
That is absolutely correct. And we could just give a quick example. Somebody who is married, but he never divorced her or him. And that person also has a common law wife. And we have had instances right here in Trinidad, and it became a big public spat. The common law wife is fighting for the body as well as the legal wife. And the
Right.
common law wife had to go to court to get an injunction for the
Right.
body to be released to the common law wife instead of the legal wife.
Right.
And
Right.
all of, These are very, very real situations. So it's not something we've taken out of a hat. We have newspaper clippings supporting that right here in Trinidad. Or I could give my current situation.
Right. So let me ask you, in terms of the legality. So we have spoken of the social implication and the legal implications, and I like that we highlight with these webinars that we are primarily a legal administrative firm, because there are a lot of parts in law that may not be strictly legal, but are legal nonetheless and affect the socioeconomic situation of the family, or just the social demographic or the experience. And will making is definitely one such legalese.
And don't forget, we have some questions. You take them, some interesting little questions there.
Yes,
I will.
Them as soon as. Yes. So in terms of Avian, so we mentioned there about the legal and the social. I want to first start on the legal to make it a bit easier and simpler. We mentioned that when you write your will, you are able to appoint your executor at some webinars before. Now your executor can be anyone when you're writing your own will. Any person.
But it should not be anyone. Yes, it can be anyone.
But it's open to your discretion.
Advise you not to use anyone.
Anyone, right. But when I say anyone, I use that term loosely. I mean it will be upon your discretion.
Oh yes, oh yes. Yes.
Someone in your in your opinion, with of course the advice of your attorney, that will be best suited for the role. Someone who can understand, have the capacity to understand their responsibility. Someone perhaps not too much older than you, so that they would not.
You are correct. You are
right.
Correct.
Someone related, or if not related, someone very close to you, so they understand your mind. Right, someone
important, somebody who is honest and who will follow your wishes. We have very, very serious problems with that.
Yes.
This person is very, very powerful. Right. And that's the only person to whom the bank will release monies.
Right.
In this instance.
Yes.
You want to be very
careful. You want to have all these considerations when you are appointing or choosing your executor or executress, or executrices, more than one, or executors, more than one, right? So you have that level measure of or order, organization, and control to an extent, right? Even though you have right. Now, outside of that, so I want to talk about a little bit about the executor's power, because you mentioned this person has a lot of power. In a will, what are some of the powers of an executor, and is it unlimited or is it within a framework, of course?
You are correct. It appears unlimited to a large extent because it's wide ranging.
Right.
That is the only person who can approach the bank through an attorney on the behalf of the deceased. This person is the administrator of everything that you would have said in your will should happen. That person also takes his or her authority from the will. So that person can begin to act on the will immediately on death. When you do not leave a will, we have to go through the process of getting the grant, and then the grantee, the person who receives the grant of letters of administration, now has authority to treat with your property unless we had gone to court and got an interim order or something to that effect. So therefore, then the executor takes his power immediately on death and can begin to treat with the property, preserve the assets, etc., and distribute property or whatever other devices, etc., pecuniary legacies that may be in the will accordingly.
Right. But of course, according to law. So this, could you speak to me, because that power seems to be, very far-reaching and wide. Can you speak to me now of the restrictions? What are the umbrella under which this executor?
Well, he or she is governed by the dictates of the will.
Right.
So he works within what you have said should happen within your will. But the breadth of his power happens from the fact that he or she begins to act on your behalf from the moment of your passing.
Right, right. Okay, wonderful. So we understand the role of an executor under a will. All right. Let's talk now about in the event that you die without a will and there's no such person appointed by you before you die. We then go into the realm now of administrator, right, or administratrix. When we speak about an administrator, walk me through some of their power, the similarities, the differences, the unlimitedness, so to speak.
Okay. So essentially, that person has to, the administrator doesn't happen until we first have to determine who is the next of kin.
Right.
If the person died with a spouse, without a spouse, with children, without children, with a common law wife, without a common law wife, with no children whatsoever. So the first thing has to happen is that we have to look at who is that person's nearest next of kin. Right. And that is the one who has to apply. Because if you're a little way down the totem pole, let's say you're a grandchild, you would have to have death certificate of the spouse. Death certificate of the child who is closer in the bloodline before we got to you. And sometimes these persons are deceased, would have been deceased such a long time ago that it takes some time to get their documents. And then you have to do all of the application, the general application, the inventory, all the exhibits that go with it, and you file those documents with the court. And generally, on an average, it takes you about 6 months at least, more or less, before you get a grant in your hand, then to now treat with what the person would have left. And then too, you know what we forgot, Miss Daniel? Sometimes you have to go digging in drawers, under the bed, under the mattress to find out what the person left. And you have to be calling, writing all the banks, writing all the insurance companies, because sometimes the person who died may have been so secretive that you have no knowledge of what they would have left, whether it be insurance, whether it be money in a bank, whether it be shares in a company or anything like that. And you have to go, you know, almost hunting down all of these places, hoping they reply in a timely manner and say, yes, we have a bank account in X name. No, we do not. You have to go looking for assets.